But despite all the evidence clearly nailing the accused, there could be some obstacles to speedy justice. With lawyers boycotting the rapist, the trial could be delayed before the court appoints a counsel for the accused. Well, it's just not the boycott of the lawyers. The long list of 40 witnesses, many of whom are currently abroad, could also deal a blow to this fast-track justice. The unabated monstrosity of this attack has stirred anger and protest. But what remains to be seen is, despite damning evidence and this being a watertight case, will the wheels of justice move swiftly enough? Let's hear what the Saket Bar Association president has to say.
Before a week, we have passed a resolution that no lawyers from this bar will appear as a defense counsel in this case. We have made a request to all the members of the bar. And if the accused is required a defense counsel, he should approach to the legal aid, and legal aid authority will give that and will not create any hindrance in that way. Because the legal aid will provide him the counsel as per his qualification and as per his as per his experience. So let him be appear that legal aid counsel will not create an hindrance for him. But we have made a request to our bar members that they will not appear as a defense counsel in this case.
Well, here's a breakdown of what could slow down this trial. The decision of the lower court to boycott the accused, well, this will perhaps delay the trial as the court will lose time before it appoints a defense counsel. The long list of 40 witnesses who will depose before the court will also take time, as some of them are even abroad. Well, the demand for death penalty could also possibly slow this process down.
It is the duty of the court to appoint a lawyer as an amicus curiae or give a lawyer from the legal aid services. So that is not a problem. They will be well represented. They will be getting a lawyer from the legal aid if nobody volunteers to appear for them. That is our first aspect. As far as the witnesses are concerned, well, in ordinary cases, yes, these kind of things would have been a deterrent. But the fact that this whole country is burning and the fact that this case is touched the heart of so many people in this country, this whether it is 40 witnesses or 100 witnesses is not going to make a difference. It is going to be taken on a day-to-day basis, on a day-to-day trial, and I don't see any reason why this would be one of the reasons for delay. It would not be.
Well, even if the authorities are able to overcome this hurdle of lawyers' boycott and the long witness list, there's one accused who may still get away. The minor, the cleaner of the bus in which the crime was committed, will be turning 18 in 4 months from now. This essentially means that the Juvenile Justice Act allows him to get away with a mere 3 years of counselling at a reformation house as punishment. The minor accused is a 17-and-a-half-year-old as per his school records, and the last hope, however, now remains in his bones. The cops have conducted a bone ossification test to determine the exact age of this accused. If he's proven to be 18 years of age, he too can be tried for murder. The cops have also taken permission from the court to carry out this test. In fact, bone ossification is not a watertight test, as it only gives out an approximate age and not an exact one. Well, the test allows for variance in age by about 2 years, which means that even if the accused is 19 years of age, his test result could reflect his age as 17, helping him escape punishment. Well, bone ossification essentially measures the bone formation along young adults, and also the process of ossification indicates the age, as generally bones do not begin to ossify till a person turns 17. Well, bone ossification has helped nail guilty twice in the recent past, where it has been able to ascertain the accused's age.